Hello, everyone. Welcome to the Canada Truth Channel, where Canada, the illusion of freedom and system of control is exposed. Today's video, a constitutional challenge to the validity of the Constitution Act 1982. Hopefully, you've seen my previous video regarding this matter. If not, I will leave the link in the description as always. If you have seen that video, this is kind of the next reasonable step, I would say. So I've been working on this case and statement of claim for a long time. But before we get into it, I'll ask you a question. Do you want to live under the rule of law that's equally applied to everyone? Or would you rather continue to live under the color of law in a two-tier justice system that's based on deliberate deception and fraud? Just asking. Okay, one more thing. Quote from Russell Roger Smith: "Never have so many known so little about so much." And in that quote, he was referring to the people of Canada not knowing about the constitutional position of Canada and the provinces. That being said, let's jump in. So I've been working on this case for a long time. And on top of all of the other issues which are not included in this case or in this statement of claim, nothing about the BNA 1867 or letters patent issued after that. Nothing in this case or claim about the Statute of Westminster or the fraudulent letters patent issued in 1947. None of that is in this claim. This claim regards specifically the way that the Constitution Act 1982 was enacted. It wasn't legally or lawfully enacted. So this case and statement of claim is specific to the procedural requirements that were not met or followed. Okay, so there's three reasons that I'm doing this. Number one, it's easy for everyone to understand this case. I've laid it out very simply with all the evidence and information included. And if you watch the video, my last video, it will make things even more clear. Number two, these are undeniable facts in law. These are facts in law. And number three, through my over 2 decades of research now on all of this stuff, on our constitutional issues in Canada and all of that stuff, and all of my research for this particular case, I was unable to find anywhere in Canadian law since 1982 a constitutional challenge that's been brought on these grounds. So literally, this might be the first time this is introduced to the courts. I'm not ready yet. I'm still working on the case, but I thought I would share my statement of claim with all of you, because eventually this case will be on behalf of Canada Truth, myself, and the people of Canada. So here we go. In the Federal Court of Canada, between Canada Truth and the people of Canada, plaintiffs, and the Attorney General of Canada, the Governor General of Canada, the Prime Minister of Canada, defendants. Statement of claim. To the defendants, a legal proceeding has been commenced against you by the plaintiffs. The claim made against you is set out in this statement of claim. Number 1, overview. The plaintiffs bring this claim challenging the constitutional validity of the Constitution Act 1982 on the grounds that it was enacted in violation of mandatory procedural and substantive legal requirements under Section 58 of the Charter of Rights and Freedoms, rendering it ultra vires and of no force or effect. The plaintiffs further assert that the Constitution Act 1982 was not properly ratified by all the provinces, in breach of fundamental constitutional principles, that its purported enactment violates the rule of law. The plaintiffs also seek clarification in the scope of the claim, acknowledging that the entire Constitution Act 1982, including Part 1, Canadian Charter of Rights and Freedoms, legislation or constitutional amendments derived from the Constitution Act 1982 may be impacted and rendered ultra vires and legally invalid by this challenge based on the court's findings. Number 2, parties. The plaintiff, Canada Truth, is a citizen of Canada with standing to bring this action as a party directly affected by the enforcement of unconstitutional legislation. The defendants, the Attorney General of Canada, Governor General of Canada, and Prime Minister of Canada, are named in their official capacity as the representative of the Crown and Government of Canada, responsible for upholding the Constitution and the rule of law. 3. Jurisdiction. The court has jurisdiction under Section 17 of the Federal Courts Act to determine questions of constitutional law and the validity of federal legislation. The claim concerns the legality of the Constitution Act 1982, which falls within the exclusive jurisdiction of the federal court. 4. Factual background. On April 17, 1982, the Constitution Act 1982 was proclaimed in force by the Government of Canada and Queen Elizabeth II through a proclamation issued under the Great Seal of Canada. Section 58 of the Constitution Act states the Constitution Act shall, subject to Section 59 thereof, come into force on a day to be fixed by proclamation issued under the Great Seal of Canada. The April 17, 1982 proclamation explicitly states, and whereas Section 58 of the Constitution Act 1982 set out in Schedule B to the Canada Act provides that the Constitution Act 1982 shall, subject to Section 59 thereof, come into force on a day to be fixed by proclamation issued under the Great Seal of Canada. Further, the proclamation declares, now know you that we, by and with the advice of our Privy Council for Canada, do by this our proclamation declare that the Constitution Act 1982 shall, subject to Section 59 thereof, come into force on the 17th day of April in the year of our Lord 1982. Section 59 of the Constitution Act 1982 sets forth conditions for its enactment which have never been fulfilled, thereby rendering the proclamation invalid. The plaintiff asserts that failure to satisfy the conditions of Section 58 means that the Constitution Act 1982 was never legally enacted and therefore of no force or effect. The province of Quebec has never ratified the Constitution Act 1982. The plaintiff will rely on historical documentation, including the April 17, 1982 Proclamation, previous constitutional acts, and parliamentary records to support this claim. 5. Grounds for the challenge. A. Failure to meet the requirements of Section 58. The Constitution Act 1982 was enacted without fulfilling the procedural requirements of Section 58, which is subject to 59. Section 59, subsection 1 and Section 59, subsection 2 were never satisfied in accordance with subsection 58. The failure to comply with these mandatory provisions renders the purported enactment of the Constitution Act 1982 invalid, making it de facto and unenforceable in law. B. Ultra vires and lack of legislative authority. The enactment of the Constitution Act 1982 without adherence to Section 58 and Section 59 was ultra vires beyond the legal authority of the Government of Canada. Section 52, subsection 1 of the Constitution states, "The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect." As the Constitution Act 1982 does not comply with its own enactment requirements, it is inconsistent with Section 52 and must be declared void ab initio. C. Breach of constitutional and legal principles. The rule of law requires strict compliance with constitutional procedures and legal requirements. Changing the name of the British North America Act 1867 to the Constitution Act 1867 did not alter its legal status from a private bill enacted by the British Imperial Parliament. The province of Quebec has never ratified the Constitution Act 1982. The Constitution Act 1982, Part 1, the Canadian Charter of Rights and Freedoms, Preamble, explicitly states, "Whereas Canada is founded upon the principles that recognize the supremacy of God and the rule of law, the failure to meet the procedural mandates of Section 58 violates these foundational constitutional principles. Any law that does not comply with its own enactment provisions is void ab initio and unenforceable in Canada." 6. Relief sought. The plaintiffs seek the following relief. A. A declaration that the Constitution Act 1982 was enacted in violation of Section 58 and therefore it is void and of no force or effect. B. A declaration that any legislation or constitutional amendments derived from the Constitution Act 1982 are ultra vires and legally invalid. C. An injunction preventing the defendants from enforcing any provisions of the Constitution Act 1982. D. Immediately call for a constitutional review and constitutional conventions. Any further relief that this honorable court deems just and appropriate. And of course, signatures dated at home in the province of Alberta on this day today. Canada Truth and the people of Canada. to the Attorney General of Canada, the Governor General of Canada, Prime Minister of Canada. There you have it. Now we'll get into the factual evidence, which I've shown you in the previous video, but it's also basically laid out in the Statement of Claim. So the British North America Act 1867, Section 91, subsection 1, with the endnotes included. The Constitution Act 1982, Sections 58, 59, subsection 1 and 2, Section 23, subsection 1A, with the endnotes included. The Proclamation of April 17th, 1982. And to kind of counter their, which I'm pretty sure they would throw out there, the de facto government doctrine. The Criminal Code of Canada, Section 15, obedience to de facto law. And because I'm sure they would say subject to is subjective and therefore up for interpretation. So I've added some case law from the Supreme Court of Canada where subject to was relevant to the case decision. So the first one, funny enough, and I can't help myself, I put it in the first one, resolution to amend the Constitution from 1981 from the Supreme Court of Canada. And here's the context. In the patriation reference, the term subject to was discussed with respect to the procedures for amending Canada's Constitution, specifically in relation to how provincial consent was needed to amend certain sections of the Constitution. The precedent. The Supreme Court emphasized the significance of subject to language in the Constitution Act 1982, interpreting that certain provisions were dependent on specific conditions, such as provincial consent and the fulfillment of procedural requirements before they could come into force. And my example here is Section 38, subsection 1 of the Constitution Act 1982 states, subject to Section 41, amendments to the Constitution of Canada may be made by proclamation of the Governor General issued on the advice of the first ministers of the provinces, so on and so forth. This was interpreted as meaning that certain sections of the Constitution could only be amended if specific requirements set out in the Constitution were satisfied. And here's the link to that case law. Next, I added Canada versus Bedford from 2013. Once again, another Supreme Court of Canada case and decision based with the use of subject to determine the decision. So the context, the use of subject to was considered in interpreting specific exceptions to legal provisions. Precedent, the court interpreted provisions that were subject to certain limitations or exceptions in determining the legality and enforceability of the law in question. The case showed that subject to provisions are considered conditional on the fulfillment of a broader legislative framework. Next, we have Schreiber versus Canada from 2002, another Supreme Court of Canada decision including subject to. Context. This case involved the prosecution of former Prime Minister Brian Mulroney and the use of subject to in relation to legal immunity under the Inquiries Act and criminal investigations. The precedent, the court emphasized that laws or immunity provisions that were subject to specific conditions could only be applied if those conditions were met. This established the principle that provision could be conditional upon fulfilling other stipulated legal requirements. And this one is fantastic because it's in the BNA 1867, now known as the Constitution Act 1867, but hopefully not for long. Section 91, subsection 1. In the Canadian Constitutional Law, Section 91, subsection 1 of the Constitution Act 1867 uses the subject to phrase. It shall be lawful for the Queen by and with the advice of Senate and House of Commons to make laws for the peace, order, and good government of Canada, subject to the provisions of this Act. Oh, the bloody irony. Precedent. In cases involving the division of powers between federal and provincial authorities, courts have applied the phrase subject to establish limits or exceptions to federal powers in the context of provincial jurisdictions, showing that certain laws or actions could be restricted or controlled depending on other constitutional provisions. The example, the phrase subject to is commonly used in the context of the federal provincial division of powers, such as when determining whether a matter falls under federal jurisdiction or is subject to provincial jurisdiction as outlined in section 92. Next, we have R versus Oakes. Now, anyone familiar with my channel will know that I've covered R versus Oakes in previous videos, as well as the Oakes test in previous videos. So, it didn't dawn on me at the time, but R versus Oakes, we have subject to as well. So here we go. Context. The Oakes test, under Section 1 of the Canadian Charter of Rights and Freedoms, involves provisions that are subject to reasonable limits that can be demonstrably justified in a free and democratic society. The precedent. The court used subject to interpret the relationship between individual rights and the limitations that could be applied to those rights under Section 1 of the Charter. Example, Section 1 of the Charter states, the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it subject only to such reasonable limits prescribed by law that can be demonstrably justified in a free and democratic society. Okay, so here's my summary of these legal precedents and their legal implications. And at the end, I've thrown in my quote. Well, we'll get to it when we get to it. Anyway, the subject to phrase in Canadian law generally means that the application of provision is contingent upon the fulfillment of certain specific conditions or qualification. It implies that a law or an action will apply unless overridden or restricted by other provisions or requirements. The courts have consistently interpreted subject to as conditional, placing emphasis on the need for specific criteria or actions to be met before the law or provision can be validly applied and kind of as a defense because for certain they're going to use that only applies to this and this and this. That's why I put the subject to in there. Um, and they're also going to probably use the de facto government doctrine, which basically is even though a government is de facto, it's illegal and unlawful. If it's recognized and carries on as a government, it's the government. So I threw in this part from the Criminal Code of Canada, which kind of refutes that doctrine because they state obedience to de facto law. Section 15. No person shall be convicted of an offense in respect to an act or an omission in obedience to laws, for the time being made and enforced by persons in de facto possession of the sovereign, power in and over the place where the act or omission occurs. So there you have it. There's the case. It's very simple, very easy to understand. There's not a lot of complex components that they could throw shenanigans at. However, I also am prepared as part of the case to introduce evidence about the BNA and all of that, about constitutional discussions, records of constitutional discussions, the anomalies with the Governor General's, the Statute of Westminster, and the fraudulent letters patent of 1947. So I have all of that information as backup, but I think this case is pretty straightforward and pretty easy to prove, and there's not a lot they can say except a bunch of bullshit, frankly. It is what it is. It's right there. I didn't write these laws. I'm not the one that didn't follow these laws, but I am a person that believes in the rule of law and not the color of law. So there you have it, ladies and gentlemen. Please use the links I provide. Verify this information for yourself. It literally takes 5 minutes for you to prove what I've just shown you here in my statement of claim. It's literally 5 minutes, and you can prove all of this to yourself and others. So please do that, and please share this information. Comment on what you think of this case. So this is a work in progress. I've got a whole bunch of other things on the go as well, including the same type of case regarding letters patent and the Statute of Westminster. So that's a separate case. I don't know if I'm going to incorporate it. I don't think so, because this is simple and straightforward. That can just complicate and convolute this very simple case and give the Crown more opportunity for shenanigans, I'll say. Anyway, thanks for watching. Stay tuned for the next video.